Now we have the review of appeals. First we have 212-18.
I thought this was an interesting case, and I thought the investigation was handled well. My only concern was that in terms of the policy, though it says, it quotes the policy that says, you know, people can't use undue influence, people can't ask for things, and you can't take those things into consideration. Great, we all assume that's the case. It doesn't say how you document those things. I didn't see anything in here that talked about if someone approaches you, you document it. You know what I mean? You know what I'm saying? And I don't know if that exists, but it seems to me that you could deal, if you had a process by which you documented someone's, or the alleged allegation that someone's trying to influence a case, an arrest or a charge, whatever, a case with APD, that there would be a way that since there's a policy that says that's not kosher, there should be a process by which that is documented. And I wondered what you thought of that, Mr. Harness.
I'm looking at the appeal and I'm not sure what aspect.
Well, I didn't see what they were appealing on, you know, on the basis of what. Yeah.
Here's this, you can have this copy, I can make 2 copies. So here's his, excuse me, this is his appeal.
Yeah, I would say that when you copy these, because this didn't come through on the scan very well. You missed the bottom of it. I read it, but I missed the bottom of it. Oh, I was thinking of the Ken Sanchez one. Is that not the one?
No, we're on 212-18.
Oh, I'm sorry. I'm on the wrong one.
Okay, now we have case 244-18, this appeal.
Yeah, this is the same.
But I would like to also mention that the individual who filed the complaint did send an email saying that he wasn't going to be here to talk about his case.
Did he have anything to add? Oh, Mr. Artist making fools out of you. Well, he's not here. This is the one I was talking about, where somebody, the ex-wife of a city councilor, complained. There is a complaint by a civilian that the ex-wife of a city councilor said that the councilor wanted to have a meeting with a detective over this case. That is in violation of an SOP policy, and that the policy being SOP 1-1-4G, special consideration, privilege, and professional courtesy. And the detective did write in the report that the sergeant asked the detective to remove the statement about requesting a meeting because it was irrelevant to the case. The detective could add a comment to a memo regarding the case, but chose not to. So that was my question, and that's what I was bringing up before. I get that there's a policy, and it's a good thing that there's a great policy on special privileges and access and using influence, et cetera, on these complaints. But there is nothing that I saw that says it's important to document this, which is, for me, in the bigger picture, it's important if you're working on the relationship between the police department and the community. There ought to be a way that says we saw this, it was wrong, and we documented it. And so I understand there's no rule that says that now, but I wonder why. And I wondered, Mr. Harness, what you thought about that. Should there be?
I think that in this investigation and as it occurred, the documentation of the negative, I guess, is what you're asking. It's documented that there was no follow-up to that request for a phone call.
I'm
And
saying
there
that
was
in a
affirmative-
report, let me be more clear, in a report in which someone has made a call to you and said, somebody in power wants to meet with you about this case. What this detective did was to talk to his supervisor, and the supervisor said, no, you're not going. And so then he wrote that in his report, and the supervisor said to him, take it out of the report, put it in a memo separate from the report because it's irrelevant. I'm saying to the community, that isn't irrelevant. And so I'm wondering if there should be some kind of a procedure or policy that says if someone attempts to do this, you document the attempt.
Well, the documentation is the memo, not in a police report.
Okay, but is there a policy to do that, or is that just happenstance?
I think that that's just how they decided to handle it in the best way. There's no...
So my question remains, should there be some vehicle by which a complaint, a request, and clearly, let's just be clear, the councilman, we have no evidence in this instance that the councilman asked for this. We have evidence that the former wife of the councilman said that the councilman wanted to meet with it. So we don't know whether he ever wanted that or not. The point is, somebody was trying to use someone's position of influence to visit with the detective in an inappropriate way, according to the SOP. It would be inappropriate. So my question is, shouldn't we say to the police department, you would be much smarter to document those things and make it part of the case to do that, because it makes you more trustworthy to the community.
And I wonder if it is required just in the general SOPs about reporting. You know, like they get a lot of training on doing a narrative storytelling, explaining everything that happened, all pursuant to SOPs that outline that. So maybe the answer is that that does exist.
Well, then you would think that the supervisor would not have said, take it out, because it's irrelevant. My point is, it's not irrelevant. And it's not irrelevant to the community. Maybe irrelevant to the police department, and good for them. You know, that's what they're saying. This is inappropriate. I'm saying if you document that it's inappropriate, that's helpful to the relations between the community and the police department. So that's my point. I don't know that it's actionable here,
Okay.
but I'm just thinking it happenstance.
I suppose. Well, I think that the distinction that the officers made at this point was what's relevant to the case to be prosecuted and what's relevant, moreover, to the conduct of the officers within the case. So
I understand what you're saying, but you see what I'm saying. For me, for example, if I had a magic wand and I could decide how this was going to happen, if someone approached one of my officers and said that to them, I, as the supervisor, would write a letter to that person saying, I understand you made this request. I'm officially telling you that's not going to happen. And that would be part of the file for that case. I would be affirmative in saying, not only no, but hell no. Okay. It's not happening.
Okay. I mean, but at this point, this is
not
an
right.
appeal.
You can't attach it to
appeal
this.
about the findings within the case and whether or not.
Yeah, and I don't have any problem with the case. I mean, it was done fine as far as I'm concerned. I am concerned about a proactive stance for misbehavior, and that is misbehavior.
Right, but that's misbehavior or beyond our jurisdiction.
Oh, yeah, but I'm just saying, in terms of a procedure for the police department to consider, that would be my recommendation to them. it's our understanding you were seeking a meeting with the counselor and the detective. That's not happening. It's against this policy, and we're not doing it. So, but you have a written record that it happened and that you responded, hell no. Yeah.
So what is alleged to have occurred here is that the officer who responded to the call originally put information in there that the woman said the counselor wanted to meet with the supervising officer, right? And then that he instructed that responding officer to remove that paragraph?
No, it was in the report. The case had to do with alleged hit and run, aggravated assault.
Right.
May have used his position to influence APD. Sanchez's ex-wife spoke to the detective requesting a meeting with the detective and Councilman Sanchez. The detective alerted the chain of command and was instructed not to do so, and he did not do so. Deputy Chief contacted an analyst for Sanchez and said the meeting was not a good idea and would not happen.
Okay. So did we investigate whether or not the alleged instruction to remove that information from the police report was an SOP violation?
Yes.
So our original investigation investigated that part. I just don't remember.
See, this is where.
Okay.
And is it kosher for them to do that, to say to take it out? Okay,
Yes.
okay. Then it's just
Had
my
no bearing-
recommendation.
Had no bearing on the outcome of the case. The district attorney confirms that they got everything they needed for charging, and it was taken to the grand jury.
Well, the outcome of the case
that
is
is
not,
interesting.
again, not in our,
Right.
in our
But the
bailiwick.
allegations were that there was influence used in order to not have
And your
charges being
investigation
brought.
showed that didn't happen.
Correct.
And, okay. So I move that we move this to the consent agenda.
No, this is an
This is
appeal,
an
so.
appeal.
Oh, it's an appeal, that we don't grant, what is the appeal based on?
And I would say that's the problem that I'm confronting because
Well, he submitted several emails, and with those emails, he had attachments. And so the best way that I could transfer that information to you is I forwarded all of the emails with the attachments to you.
And is there anything in your view that means that they've met the standard for an appeal? Is he appealing because he doesn't like what we said, our findings?
My reading of what he's asking for is that he's asking for us to interview things outside of EPD, which we don't have the ability to do.
Okay. So then, Chelsea, do you have any thoughts on his request of an appeal?
I have some thoughts, yeah. I mean, I would say it seems he's really focused. I mean, he focuses on this, but he also focuses a lot on the Officer D case. And he doesn't have standing to appeal the Officer D case. So I think we should just, put that on the record at the board meeting, because a lot of his email response was focused on that. And then as to his case regarding this leaving the scene of an accident situation, I would also like us to put on the record that we don't have any authority to investigate city councilors. That's just not, we're not allowed to do that. So, I mean, I'm sure that people would like us to do that from time to time, but we're simply not allowed to do so. So I would like to put that on the record. As to whether or not there were SOP violations that we didn't flag or didn't adjudge correctly, I think that it is Mr. Delangela's burden to lay out clearly which of these appeal criteria he's appealing on. And so again, the four are laid out to him in his letter, which was the APD policy or APD policies that were considered by the POE the wrong policies or used in the wrong way. Was the APD policy or APD policies considered by the POB chosen randomly, or do they not address the issues in your complaint? Where the findings of the POB had no explanation that would lead to the conclusion made by the POB, or where the findings by the POB were not supported by the evidence that was available to the POB at the time of the investigation. It's really hard for me to discern from the type of stuff he sends us, whether or not he is flagging any of these actual appeal criteria that we're allowed to use pursuant to the CASA. Because it really is just like, kind of like these long emails that complain about a number of topics, a number of government officials, a number of city actors. And so, I mean, I would say that he has 30 days from the receipt of his letter to file an appeal. And if he wants to file an appeal, then he has to give us a specific criteria and a basis for that criteria. So if he's saying, for example, that we didn't use the right SOPs, he needs to actually do the research and bring the SOPs to us. That's how you would satisfy this type of appeal request.
Well, and we were not asked in this complaint to investigate the event for which he claims the councilman was using influence or was alleged to be using influence. We are talking about that as the issue. Did the was influence used on APD in this case? And that's the question we're answering.
And if so, did APD do anything wrong in that situation?
And we did that. I'm satisfied that we did that.
I mean, because anyone could pressure an APD officer to do something inappropriate, but it's not inappropriate per our investigation unless the APD officer then did something inappropriate, right? And the investigation we got back didn't see anything like that. So, I mean, with what we've been given now, I am not in a position to recommend the granting of an appeal. And I would recommend the denial of an appeal. And if he wants to try to be a lot more specific, then maybe we could consider that if he can get it to us in time, but right now I just don't think it's there.
Is that a motion?
Is that a motion?
Right now I would move that we,
Deny the appeal.
recommend to the board the denial of the appeal.
I second that.
All in favor? Aye.
Aye.
Okay.
I think it's important that you keep in mind he was specifically asked after 2 of these emails, is it his intent that this be an appeal? So I think that should be cognizant of the fact that these submissions are his appeal.
Yeah, and I would just like to put him on notice that, that was insufficient. And if there's gonna be, appeals based on things that are happening, or if if we're gonna get cases like this from members of the public on a third-party type of basis, and get like a series of appeals and renewed requests, that those members of the public need to really try to be much more specific, because we are very, very bound by the parameters in the CASA. It's not like it's definitely not like we can just kind of take whatever we get. It has to really satisfy this, and so I would like those members of the public to be aware of that.
Okay, thank you.